Moving further, friends, the inherent challenges to drafting are not just that. The next big aspect that comes about is with regard to confidentiality and non-disclosure agreements. Now, you may see that when you're entering into a transaction, you would want it to be of absolute secrecy. You will want some particular aspects of the contract to be kept confidential so that no competitor of yours comes to know in case you are a businessman. In this context, it is pertinent to note that Coca-Cola is one of the largest kept trade secrets across the world. Now, how do you maintain this? Now, if you're looking to enforce the aspect of secrecy and confidentiality with persons with whom you are engaging in the business, like say there could be multiple people who come into the business. You would have partners, you would have vendors, you would have service providers, you will have customers, you will have employees who on a day-to-day basis engage with you in the business. On whom can you impose a confidentiality or a non-disclosure clause? This is one of the foremost questions which every draftsman is required to understand. Now, we have discussed time and again that the aspect of employment is something to be looked at on through the lens of Section 27 of the Indian Contract Act. What does this say? It says any agreement that is in restraint of trade employment is void. Now, that being the case, is a particular condition about disclosure or non-disclosure of aspects relating to employment a restraint on trade or employment? What do you think? Please note that it has been clarified time and again that the aspect of restrictive covenants such as confidentiality and non-disclosure agreement is something valid which can be imposed on any person who is on an equal footing. The condition for you to understand is, are parties under the rule of pari delicto? If the parties are falling within the purview of pari delicto, that is on equal footing, then in those circumstances a confidentiality and a non-disclosure agreement shall stand valid. But however, if one or more of the parties on a different footing, like say for example the relationship between an employer and an employee, a doctor and a patient, a teacher and a student, a father and a son, in those circumstances the contract cannot be said to be in pari delicto. It could be because of fiduciary capacity of the relationship or any other superiority or subordinate relationship, whatever the may be the case. In those circumstances, even if a particular clause, such as a confidentiality and a non-disclosure clause, is drafted, the same will not be allowed to be enforced. The only rule or thin rule of exception is that with regard to your employment related aspects. Now, in employment related aspects, there are divergent aspects that you need to keep in mind. One is during the subsistence of the employment and after the completion of your employment or termination of your employment. During the subsistence of your employment, a non-disclosure agreement or a non-disclosure clause can be enforced against an employee, but the same cannot be implemented or enforced after the termination of employment. In the sense that the case that is in hand, that is Ambience India versus Sri Naveen Jain, it so happened that there was an injunctive relief that was sought against Mr. Naveen Jain with regard to his employment in a particular industry. Now, the person was a specialist in fabric related technology, and during his employment tenure, he was subject to a non disclosure, a confidentiality, and a non compete clause. Now, what was the impact of these clauses? The impact of these clauses was that he could not use the knowledge that he gains in ambience in any other employment that he is to carry forward. That is what the confidentiality agreement does, my friends. It prevents another person from using such information which has been acquired by a single party to the contract. In this case, Ambience India's knowledge, the information was picked up by Mr. Naveen Jain during his employment, and subsequently upon termination can he be prevented from joining another similar business. The courts have clearly put across that such a particular restraint will become void by virtue of Section 27. So, understanding a clear aspect of the position of law and how it is implemented in these contracts is also an essential thing that you need to remember while drafting a confidentiality and a non-disclosure clause. Moving further, the non-compete clause, the similar aspect applies to. It has been well etched in the Indian jurisprudence that any non-compete clause cannot be extended beyond the term of the contract. If the employee is to resign, he cannot be prevented from joining even a business of a competitor. But what is the relief that you can have in order to prevent? Please note, owing to these plethora of cases, there has been a development that has come into existence called garden leave clauses. In the sense that when an employee wants to resign, there is a mandatory notice period that is carved out into an agreement. Now, what does this do? Even though an employee wants to vacate, even though an employee wants to resign from the company and join a competitor, in those circumstances, especially with regard to businesses where there are high amount of confidential path breaking information that is being exchanged with the employees and the management, or if the employee is a person belonging to the top key managerial position, in those circumstances, if such information goes to the competitor, it would be detrimental to the business. So, in order to prevent such aspects, the garden leave clause ensures that there is a mandatory notice that is required to be given by such employee to the employer, and only after completion of such period can he join the competitor or any other person whatsoever. My friends, you may say, what is the impact of this? Please note, if any information is worth protecting, only then confidentiality clauses are executed into. If such information is worth protecting, then it is worth covering the notice period of your employee. It may look across that you are paying across an additional salary for the employee during the garden leave clause. Essentially, it is called garden leave because during this tenure, the employee will not be given any day-to-day activities. He will only be required to come over to office, complete his handover of or complete necessary basic formalities, whatever the need be, and then return back home. He will not be engaged into the day-to-day activities of the management nor of the business. So therefore, especially in volatile businesses, like say for example, with regard to technology and certain other aspects where innovations and the obsolescence of technology is quite high. In those circumstances, having such garden leave clauses is much worthwhile. But the same may not be the case in a lot of other businesses. So, in those circumstances, the notice period that is required to be given by the employee can be sufficiently managed. The greater the secret of the information, the higher the notice period for your garden leave clause. The lesser the importance of the information, the lesser can be the notice period. The next challenge that comes across is with regard to drafting of arbitration clauses. Now, you might ask me, what is the big deal? It is just an, manner of dispute resolution. Why should we have immense care and precaution while drafting it? Please note, friends, the misconception is that these arbitration clauses are generally not those clauses that are drafted immediately when the contract is executed. Like say, for example, if you're going to do a business, you are first going to discuss about the commercials of that business, and only then you will come about to the drafting of the agreement. You are not going to discuss with the person saying that, okay, tomorrow if you're going to have a dispute, let us first settle by arbitration, and then you will not come down to the commercials. You first discuss the commercials, and only then thereafter you decide, okay, in case there is going to be a issue, where do we go to? Now, let me tell you again, friends, as discussed in the previous videos, arbitration clauses are called boilerplate clauses because in most circumstances there is a copy paste of the clause that is done. I have an interesting case before you for you to understand why it is pertinent to note how an arbitration clause can be misinterpreted. Please note, friends, the law of arbitration, that is the Arbitration and Conciliation Act, clearly provides that the seat or place of arbitration for determination of the law that is applicable. Please note, my friends, it is a clear position that whichever is the seat of arbitration is where the law or the courts will have jurisdiction, not the place, not the venue. Please note, the law makes a distinction between seat and place. The term venue is not used anywhere else. So it was a question of challenge where a contract was executed as to whether the mention of London as the place of arbitration, whether it is to be construed that London is also the seat of arbitration. Please note, my friends, seat, place, and venue, if used interchangeably, the position of law can be much different because the law recognizes only seat of arbitration for determining the jurisdiction. Place or venue of arbitration can lead to a confusion in the state of mind in the courts, and you might be creating a lacunae in interpreting the contract. So please use appropriate words while drafting an arbitration clause. Second to it, an arbitration clause which is loosely drafted, saying that all the parties shall refer to an arbitration without defining as to who the arbitrator is or the manner in which the arbitrator is to be appointed or the manner or place where the arbitration shall take place shall give a cause to ambiguity in enforcement of the contract. So therefore, these are the particular things to be kept in mind while drafting an arbitration clause. Similarly, there may be an instance where even though there is a particular arbitration clause as seen under the ONGC versus SAW pipes case, the concept of public policy is something that can intrude into the interpretation of the arbitration clause or the award that is passed by the tribunals. The Antrix episode is also another aspect that is to be kept in mind as to how an arbitration existence of an arbitration clause can impact a contractual performance. Friends, this was a case where the Antrix Devas had executed into a contract. Now it so happened that Devas was a company which reconstituted itself in the sense that there was some amount of shares that was held by few of the shareholders in Devas, which was sold across to another shareholder, owing to which Antrix had the opportunity to terminate the agreement. But merely because there was an arbitration clause, the matter could not be determined by the courts in India. It had to go for an arbitration. And after several rounds of arbitration in multiple jurisdictions, India faced a backlash. Now, the existence of an arbitration clause is something that can intrude into the contractual implementation as well. Because when there is an arbitration clause that is given and the powers are vested with an arbitral tribunal, the same cannot be revoked at any point unless there is a novation of the agreement between the parties. So please note, my friends, it is always important to understand in what circumstances arbitration can be provided for and in what circumstances it cannot be. On this note, I would like to bring about the aspect of the Commercial Courts Act. Please note, friends, with the Commercial Courts Act, which has come into existence, there is a chance for a faster, speedier, and a more cost-effective dispute resolution that can be carried out in case of commercial transactions. So therefore, the Commercial Courts Act have now today limited or minusculed the role of arbitration in India because of the manner in which the time-bound determination of dispute is provided for by the Commercial Courts Act. And further, there is a standard operating procedure that is created by the courts across India with regard to commercial disputes, particularly in the form that there are special courts in few states. The high courts are the special courts that have been warranted with the jurisdiction to handle commercial disputes. That being the point of concern, please look into the drafting of arbitration clauses, keeping all of these points in mind. The next aspect that you need to keep in mind is in case one or more of the parties in the contract is a MSME, in the sense a micro, small, or medium enterprise. If they are either of a micro, small, or medium enterprise, please note even if there is an arbitration clause in the contract, the MSME Act supersedes the same, in the sense that even if there is an arbitration clause, the micro, small, or medium enterprise can definitely approach for the disputes facilitation center that is created within the MSME Act. This dispute facilitation center is available on the portal called eSamadhan. So therefore, having an arbitration clause well drafted or inserted into a contract does not necessarily mean that it can be enforced accordingly. The implementation of the arbitration clause differs from one transaction to another depending upon the nature of the parties and the purpose for which the agreement is executed. The aspects to be kept in mind while drafting preemptive rights are multifold. Now, the first thing that you need to understand is what is a preemptive right. The preemptive right is something that gives across a step in advance to one or more of the parties. What does it do is that when there are two parties in a contract, or maybe two or more parties in a contract, it so happens that in case one of the parties decides to, let us say, carry out a particular action or not, the other party is given a right to choose whether such person should carry it out or not. This may be understood from the aspect of enjoying a common property. Let us say that there are three brothers. All three brothers have a share in the land, which is their ancestral property, which is currently being enjoyed as a joint property. Now, it so happens that one of the brother decides to sell his share in the land to a third person. Having a preemptive right in a contract allows the other two brothers to get the first right of refusal, to choose that the share in the property of the seller brother can be purchased by the existing brothers themselves, either solely or jointly. Now, this is what a preemptive right does. It tries to prevent any third person from being engulfed or brought in within a particular transaction by providing one or more existing parties the right to choose to perform a particular action in addition to their obligations under the contract. This clause is quite most popularly used in this clause in a contract is most popularly used in aspects of transfer of property, and you might have come across into understanding that a transfer of property takes place on multiple aspects. So there is a lease, there is a mortgage, there may be a hypothecation with regard to each one depending upon the nature of the property. Now it so happens that in case of a lease, the right to sublet can be created by way of a preemptive right, in the sense that if the lessee wants to sublet the premises, the lessor can withstand or hold a preemptive right to not allow that sublet. So that is the particular aspect of what a preemptive right can do. Second to it, in the aspect of a mortgage, a creditor can put in a particular preemptive right stating that in case there is going to be any subsequent charge or mortgage that is going to be created on the property, the consent of the creditor shall be availed before going ahead with such transaction. These are aspects or in the manner in which preemptive rights protect the interest of one or more parties. Now, in the example of the creditor, if suppose the preemptive clause is not there, it may so happen that the borrower will take a second or a subsequent loan, which will actually affect the right to recover the entire loan amount from the sale of such property or the proceeds of such sale of property in case there are two or more subsequent loans that are taken in the same. Now, that is the manner in which preemptive clauses can be drafted into a contract in order to ensure that the contract is enforceable. The next aspect where preemptive contracts come into importance is with regard to your corporate transactions. Now, in a corporate transaction, the major conflict or dispute is essentially between the investors and the shareholders. So generally, the investor takes shares in the company, which is promoted by the shareholders, and a minor stake of the investor is taken for a major chunk of money, which is given as investment. So in those circumstances, there are certain preemptive rights that are carved out for the investors. What are they? There could be investor protection matters that could be carved out, which says that if any particular item which is listed under the heading of investor protection matters, those aspects shall be done only with the consent of the investor. So that is the aspect on which a preemptive right operates in an investor shareholder dispute. In the alternate, a shareholder or a promoter can also have a preemptive right stating that if the investor chooses to sell his shares to, let us say, Mr. Y, then the existing shareholders shall have a right to purchase such shares. So this is a particular clause which can be drafted in case a preemptive right is required for the existing shareholders as well.